Tonight, we are looking at the Special Marriage Act and Muslim personal law. In fact, not just the Muslim personal law, even other personal laws with respect to marriage from the lens of a verdict from the Madhya Pradesh High Court, which appears to be hugely contentious. The Madhya Pradesh High Court dismissed an interfaith couple, a Muslim man and the Hindu woman's petition for protection and assistance in their marriage under Special Marriages Act. And the ground to do so is where the concern lies. The couple had specified to the court that neither of the partners want to change their religion. And that's why they want to marry under Special Marriage Act, saying they were in love with each other and did not want to be in a live-in relationship. They said they have already approached the marriage officer under Special Marriage Act, but because of objections raised by the family of the woman, they are not in a position to appear before the marriage officer. As a result, their marriage is not being registered. They wanted protection to be able to go and register their marriage. The family has claimed that if the marriage does happen under the Special Marriages Act, this is the family of the couple, the girl in this case, the father of the boy's father would be boycotted by the society. That's the one version of the family. The questions to the court were directed on whether the marriage of the interfaith couple would be a valid marriage or not. As we proceed to see why the court dismissed their plea, let me quote from the excerpts of the court verdict verbatim. This is not what I usually do, but because the court has also gone to make their grounds very clear on how they have arrived at this conclusion, it's important to read excerpts of the verdict as it is. One portion that I'm reading out. Under personal law, performance of certain rituals are necessary for solemnization of marriage. Fair enough. Goes on to say, however, if marriage is performed under Special Marriage Act, then such marriage cannot be challenged on the grounds of non-performance of such mandatory rituals. Again, fair enough. Now, here's the point. But marriage under Special Marriage Act would not legalize the marriage, which otherwise is prohibited under personal law. Is that really what the case is? That an interfaith couple's marriage under Special Marriage Act would not legalize the marriage which otherwise is prohibited under personal law. The court goes on to say, as per Mohammedan law, the marriage of a Muslim boy with a girl who is an idolatress or a fire worshipper is not a valid marriage. Fair enough. Even if the marriage is registered under the Special Marriage Act, the marriage would be no more a valid marriage and it would be an irregular marriage. And ironically, this is of course the verdict from the Madhya Pradesh High Court. Now, ironically, there is a contrasting judgment from the Allahabad High Court today itself on a very issue of interfaith couple who are living together and wanting to marry under Special Marriage Act soon. The Allahabad High Court has observed that the law does not prevent an interfaith couple from applying for court marriage under Special Marriage Act without the requirement of converting their religion. Two courts, two contrasting views, the same laws under the scandal. I'm being joined by a panel of experts at this point. I'm being joined by Advocate Dinesh Upadhyay, who's the lawyer for the couples in this particular case. I'm also being joined by Karuna Nundy, who's a senior advocate, senior Supreme Court advocate, Amber Zaidi, who's an activist, Ahmed Ayaz, who's a lawyer, Atiq ur Rahman, who's an Islamic scholar. Thank you very much, all of you, for joining us. Allow me a few minutes. I'm being joined by Advocate Dinesh Upadhyay at the outset. Allow me a few minutes because we'll just spend a few minutes with him to understand, because he's the lawyer for the couple in this particular case. Advocate Dinesh Upadhyay, thank you for joining me right now. My very quick questions to you. What is the couple's next plan of action? What are they now intending to do? What are you intending to do?
they are intending to do is only filing the writ appeal before the division bench, because there is a provision under the law. If any person aggrieved the order of the single bench, they can approach the writ court by filing the writ appeal. Therefore, they are ready to filing the writ appeal, and next Monday it will be filed before the court of law.
Okay, so you are saying you're going to challenge this particular verdict?
Yes,
you're going to file a plea challenging this particular verdict?
Yes, yes, yes.
Advocate Dinesh Upadhyay, whatever verdict you've got from the court, what do you make out of it? आपका इस कोर्ट का जो verdict है, आप हमें explain करेंगे, आपका क्या inference है इस कोर्ट के verdict का?
The court का verdict accordance on discussion, but it is not a correct view taken by the honorable single bench. It's not correct, because that this case is not filed under the Mohammedan law. They have filed the petition before the marriage registrar under the Special Act, Special Marriage Act, and it is settled principle of law. Special law will prevail over the local law or personal law. In the honorable single judge which has been decided the issue considering the Mohammedan law, but present case that Mohammedan law is not applicable, as there is a specific law that has been introduced by the law for the purpose of this situation, and interreligious marriage, intercaste marriage. For
Dinesh
that purpose,
Upadhyay
there
ji,
is a specific law. Therefore,
Dinesh Upadhyay ji, will you help us understand what did the couple tell the court? Couple का कहना क्या था कि वो स्पेशल मैरिज एक्ट के अंदर के तहत शादी करना चाहते हैं, बट वो वहां तक जा नहीं सकते हैं क्योंकि ऑब्जेक्शंस है और उनको प्रोटेक्शन चाहिए जाके वो रजिस्टर करे. उनकी मांग ये थी. उनकी मांग क्या थी कोर्ट के सामने?
बस यू आर करेक्ट. उनकी मांग यही थी कि चूंकि उनके लड़की के पेरेंट्स और अदर उसके फैमिली मेंबर्स से थ्रेटनिंग मिल रही है लड़के को, और यदि वो नेचुरली कोर्ट में जाते हैं रजिस्ट्रार के कलेक्टर के सामने, तो उनके साथ मैन हैंडलिंग भी हो सकती है, कोई घटना भी घट सकती है. क्योंकि पुलिस भी प्रेशराइज कर रही है तो पुलिस अरेस्ट भी कर सकती है. इसलिए उनकी जो मेन मांग थी कि प्रोटेक्शन दिया जाए और उनको अपीयर होने दिया जाए बिफोर द मैरिज रजिस्ट्रार.
Okay, so I just translate very quickly what Advocate Dinesh has said. He has said the couple wanted the protection to be given to them so that they can go to the registrar, magistrate and get their marriage registered under the Special Marriages Act. So court ने फैसला तो दे दिया कि ये dismiss कर दिया petition, लेकिन कोर्ट ने उनके प्रोटेक्शन के बारे में, उनको जो कंसर्न था उनके प्रोटेक्शन के बारे में, उसके बारे में कोर्ट ने कुछ बोला कि उनको प्रोटेक्शन दिया जाए या ना दिया जाए, कुछ बोला उसके बारे में?
नो, कोर्ट ने रिजेक्ट कर दिया. कोर्ट का ये कहना था कि यदि अगर हम इनको प्रोटेक्शन देते हैं तो इस रेगुलर मैरिज का पार्ट हम भी बन सकते हैं, इसलिए हम इनको प्रोटेक्शन देने का ऑर्डर नहीं कर सकते. They have refused to grant the
कपल कैसे हैं अभी? ठीक है, वो सेफ है?
नो, इट इज नॉट करेक्ट. बट आपको एक इंफॉर्मेशन में देना चाहूंगा कि even otherwise today they have got order for division bench for granting the protection. One habeas corpus petition filed by the father of the girls, in which today hearing took place, and that matter division bench of the Honorable Court, High Court of Madhya Pradesh, already been passed and directed the police station to provide the protection to girls and boys.
Okay, that's fair enough. So that's a decision that has been taken henceforth. Thank you very much, Advocate Dinesh, for joining us, for giving us perspective. We wish all the best to the couple. All right, let's just get to our panel of experts at this point. Karuna Nundy, if I can come to you first. What do you make out of this court's verdict? I have a couple of questions, but let's just start with what your key observations in this point is, because I had to read this couple of times and reach out to legal experts to get a sense of whether what I'm reading is correct or not, because it just didn't seem to be in place. But I'm not a legal expert, Ms. Karuna Nundy, please go ahead.
Sneha Koshy, your instinct was exactly right and legally actually quite spot on. This judgment is as far from law as Mars, actually, because if you look, for example, at the Special Marriage Act, it was established, if you just read the objects and reasons, it was created in order amongst other things, to enable people who wish to opt out of the religious regime that they are born under and marry in a manner that is just as per law, that is not as per their religious law, right? And so, for what's also very interesting about this judgment, sometimes you have the lawyer who has not pleaded the correct law before the court. That's not the case here. Advocate Dinesh pleaded the correct law. There are perhaps other judgments that he could have cited, but he quite correctly cited the Lata Singh versus the state of UP judgment, right? In Lata Singh versus the state of UP, the Supreme Court came down very heavily on the brothers of Lata Singh who objected to the Gupta family of the groom, beat them up, locked up the brother of the groom, starved him for 5 days. And they said that not only would the couple be protected, but criminal action would quite rightly be taken against the family. This also highlights a problem under the Special Marriage Act. Of course, this judgment will go up and it'll be struck down. It'll be set aside rather. But it highlights a problem in the Special Marriage Act, which is, why is there a notice period? Why should the public at large be told that a couple is getting married? Surely it is a matter for the two of them. In judgment after judgment, it is said that there is some privacy to be accorded to marriage. This is something that we had pleaded also in we as in collectively, not me, but another counsel, in the queer marriage case. Because when we were seeking that queer marriage be recognized under the Special Marriage Act, we were saying that this notice period should be done away with, because it enables anyone and everyone, anyone walking on the road, to suddenly say, oh, I have an objection to this marriage, get a mob together and threaten my safety. So therefore, where does this leave us? In this judgment itself, in the queer marriage judgment, it has been said that queer couples will be protected. I beg your pardon, protected. Here, there is a long line of judgment saying that if there is a threat, that of course the couple will be protected. So the problem is not this judgment. The problem is something larger. That rule of law here has been set aside. And why is that? Because we see a trend in which, due to the unity that some political parties are seeking to bring between the government and the judiciary, there is now a new incentive for judges to act in a way that is not as per law. I hope that this is only confusion. One doesn't want to read motives into it. But this is a real danger. With the Calcutta High Court judge, for example, joining the BJP, with Mr. Gogoi, a former Chief Justice, becoming a Rajya Sabha member, this is a real problem.
You're making very important points, Karuna Nundy, and we really hope this is just a confusion in this case, because it was a confusion that was even hard for us to work our way and navigate our way through. But let me just get in Ahmed Ayaz at this point. Ahmed Ayaz, two parts. To what Karuna Nundy has said, and there are two parts to this. One, the court says that the marriage will be invalid or irrelevant. If I can use the correct word, irregular under the Muslim law. That's one part. But the court also goes on to say, and that is the contentious part, that marriage under Special Marriage Act would not legalize the marriage which is otherwise prohibited under personal. So there are two parts. It's not that the court is saying that SMA will not be recognized under the Muslim personal law. That's one part. But the court goes on to say that marriage under Special Marriage Act would not legalize the marriage which is not recognized by the Muslim law. Ahmed Ayaz, please.
See, here it's a matter of interfaith. Here it is a matter of interfaith marriage, and what the MP court has said is the correct thing. The Constitution allows to recognize personal laws through Article 25th, right? So that way court is very correct, and any Muslim cannot marry a non-Muslim unless there is a conversion, excepting some concession with the categories on the book of people. So here the court has rightly decided no Muslim can marry a non-Muslim unless there is a conversion. So now we say that Marriages Act is there in place, and how can it be? Because then you'll have to see that the Constitution also recognized personal laws through Article 25. So here the court has decided the right thing. Marriages Act cannot, ride over the
Are you saying that the court is
personal laws.
correct? I'm trying to understand, and I made it very clear. The point is not about the marriage being invalid under the Muslim law. That is not the point. The court goes on to say, and I'm reading this again so that I'm not getting you wrong on this, sir. The court goes on to say, but the marriage under Special Marriage Act would not legalize the marriage which is otherwise prohibited under personal law. The court literally is saying that even if you marry under the SMA, that's a Special Marriage Act, it's not going to be legal.
True, it cannot be legitimate. Why? Because it is already recognized under the Constitution. You have recognized personal laws under Constitution. So when you recognize the personal laws under Constitution, naturally it cannot be override. There can't be no override. So that's why any such marriage, unless it is done as per the rituals of the laws, personal laws, cannot be legitimated. That's what I say. The court has done the right thing here by saying that the marriage cannot be legitimate
Karuna Nundy,
unless
please
it
come
is
in.
done as per the
Okay,
personal laws.
I get your point. I need another legal perspective to this. Karuna Nundy, two lawyers, two very different opinions, and two courts, very different opinions. I know, Amber Zaidi, you're raising your hands. I'll just come to you. Allow me to just go to Karuna Nundy. Karuna Nundy, go ahead, please, quickly, a minute before I go to Amber Zaidi.
I'm afraid Advocate Ahmed Ayaz may be allowing his feelings to override what the law is today. What the law is today, sir, is the Special Marriage Act coexisting along with personal law. Your interpretation would be correct if you were speaking of two individuals of different religions getting married under Muslim personal law. Perhaps you could open the Special Marriage Act, 1954, which is perfectly crystal clear. It allows persons, not just Indian citizens, but also foreign citizens, if they have resided for 30 days in India, to marry under the provisions of the Special Marriage Act, if the marriage is not bigamous, if they are of marriageable age, etc., under the Special Marriage Act. There is no doubt about this. If you have a particular constitutional interpretation of whether the Special Marriage Act should exist or not, that is a separate issue. Currently, that is the law. There's no debate on that.
Okay, Amber Zaidi. Okay, Amber Zaidi, you were raising your hands. Please go ahead. You had a point to make. And I would particularly be interested in how you look at what Ahmed Ayaz has said, what the court has said as well. Because Ahmed Ayaz is totally backing the court's verdict in this point. And I'm again, just for the benefit of our viewers, really saying, this is not the court trying to say that the marriage is invalid under the Muslim personal law. The court is saying even if you go and marry under the Special Marriage Act, it's going to be invalid. Then what is the point of a Special Marriage Act?
Sneha, this is not the first case that we are witnessing. The contradictions in court judgment. Earlier also, I witnessed such cases, similar cases, and you see the different judgment in similar cases. I'll give an example of Chandigarh Haryana High Court and one Kerala High Court. They were similar cases, and one couple went to the court for seeking the custody of her underage wife. And in both cases, and Kerala High Court said, if your wife is underage, and hence the rape charges should be applied on you. And on the other case, it was like that the custody was given to the husband. And now in this case, but if we talk about the Special Marriage Act, as per the Section 4 of Special Marriage Act, only you should be as individual, the singles who are getting married, they should be legal age of, their age should be legal, and they should be marriageable age and they should be single and then mentally sound and nothing else. It does not override anyone's the right of choosing their partner. Their personal faith and their religious doesn't matter. The lawyer, Mr. Ahmed Ayaz, whatever he said is absolutely unfortunate, and because of the such contradictions, we went to the Supreme Court of India for the implementation of uniform civil code in the country. And such injustice Muslim women are facing because of this horrendous cases and this selective judgments from the high courts. And this happens because we have a special marriage, such provisions in the law, the laws based on their personal faiths and religions. And as per the Supreme Court, or sorry, as per the Constitution of India, we all have equal rights. And what about the individual right to choice? As he said, the judgment was absolutely all right as per the Article 20. What about the freedom of right to choice? If I want to go and choose somebody out of my personal faith, so as per this judgment, I'm not allowed to do that, and my marriage will be illegal. So what this judgment was, at initial stage,
marriage
it looked like
illegal is a different point. Here the couple is not being allowed to marry is the problem. Under any act, neither the Muslim, neither the SMA, but I get your point completely, ma'am, at this point. Let me just go across to Atikur Rahman. Atikur Rahman, two courts.
It was looking like it was given by some Sharia court. I'm so sorry.
Okay. Let me just go across to Atikur Rahman. Atikur Rahman, you have the Madhya Pradesh High Court verdict. And then you have the Allahabad Court verdict. Allahabad Court verdict on the same subject, where there are two couples, interfaith again. They do not want to convert. Both the cases, they did not want to convert into each other's religion. The couples had made it very clear. And in Allahabad High Court, again, the court goes on and say there is nothing that stops them from marrying in under the Special Marriages Act. Atikur Rahman.
So, Sneha, I would go by the Allahabad High Court judgment. I would go completely by the Allahabad High Court judgment. The MP High Court is erroneous. Why it is erroneous? Because, to me, the culmination of the Special Marriages Act was a fight between orthodox elements in our society and liberalism. The enactment of the Special Marriage Act was giving liberty to the couples that without going into the hitches of religiosity, they can marry within the Indian law, which permits them without having any conversion, they can live together. That was the main purpose of the Special Marriages Act. How can a High Court be expected that the real purpose of a particular act which overrides the personal laws? And most important factor, Sneha, over here is, I am not going to the court in this matter. The couple is not going to the court for the enforcement of personal laws, but they are opting for a Special Marriages Act. So how come the High Court is giving an erroneous judgment saying that no, Special Marriages Act is not upheld, but personal laws are upheld? So I am completely disturbed about this element, and the High Court of Allahabad is completely right in giving this couple, the other couple in the other matter, complete protection. And I worry that this particular couple which went to the MP High Court, how their lives are at risk. They should be immediately given protection.
You made such a valid point, Atikur Rahman, and that's my next point. I don't have much time, but I think this is a very important point to touch upon. Even as Atikur Rahman raises this concern about how that couple would be, that was one of the first thoughts. Of course, their lawyer has told us on the channel right now that they eventually moved a division bench. The division bench went ahead and gave the order for protection, police protection. Karuna Nundy, is it on more than one grounds that the Madhya Pradesh order seems to be contentious because it's not just about the interpretation of the Special Marriages Act. It also seems to have lost ground or lost sight of what really the heart of this petition by the couples were. They wanted protection to be able to go and register their marriage. One of the critical aspects of this is one, to get married under the Special Marriages Act, but the second part was the appeal for protection, that they fear they're not able to even go to the magistrate's place. And that seems to have completely fallen out of sight.
The fact that the Madhya Pradesh High Court, I'm hoping due to legal ignorance and confusion, and that's the best case scenario, failed to respect the Article 21 right to life of this couple is something that is so egregious that at the very least, I believe that the particular judge, there must be action taken on the administrative side and retraining. They have to consider what action should be taken. Is it going to be retraining at the National Judicial Academy? Is it going to be suspension for a period? But something must be done. The second thing is that I was startled to see that a fellow lawyer would take the stand that our fellow panelist did, but heartened to see that the Islamic scholar on your panel is taking the view that, look, there is the personal law, and if you want to get married under the personal law, it is available to you, that religious people have their domain of their own religion, so long as they meet the floor of fundamental rights. And for everybody else who wants to be a citizen of this country, there is the Special Marriage Act and other such laws. And that, I think, let us take away on that heartening note the fact that the division bench is protecting the couple, and today the rule of law has ultimately prevailed. There are a number of judgments. There is no doubt that this Madhya Pradesh judgment is per curiam. This is not a matter for debate. There are some laws, there are some issues, there are some judgments that you could have 2 views on or 5 views on. This is not one of them. So gratitude is due to the division bench for acting quickly, and also kudos is due to the lawyer for moving fast and for making the correct plea, frankly, before the single judge and presumably before the division bench.
Right. Ahmed, I ask my last question to you. You've heard everyone on this panel, including Karuna Nundy, Amber Zaidi, as well as Atikur Rahman. Do you think what has happened in Madhya Pradesh court today is possibly something that does require a deep looking within the legal system of how laws are interpreted per se?
You see, everybody is free to his or her opinion, and inferences can be drawn from the judgments and court decisions. That's of course there. But here I again reiterate that the court perhaps has gone through recognizing, the right of individuals, recognizing their personal laws under through Article 25. So I think that is the thing where the court perhaps has its decision is based on
and then what about the Allahabad High Court, sir?
article, which
what about the Allahabad High Court then?
Which wait, let me complete. Okay, that must have taken a different view. High Court must have taken at Allahabad a different view. But here, when we say that, how is the MP court allowing it? How is not recognizing it as a legitimate marriage? It is just because must have gone through the Article 25, which allows to recognize the personal loss of a person. So I think that judgment is based on that. This is what I can, sitting here, I can say that there seems to be a point for the court to decide on those lines. What Allahabad the court has taken a view that of course
Atikur Rahman,
we don't know
do you want
exactly.
to respond very quickly?
Maybe they
The last
taken,
1 minute to you, Mr.
special...
Atikur Rahman.
Yeah, Mr. Ayaz, you are completely wrong, sir, my good friend. Here the couple and mainly that Muslim boy is not going to the court asking for protection of his personal Islamic laws. He is going for a secular law which says that he has a complete freedom to have an intercaste marriage, interreligious marriage. If I would have gone to the
Interfaith.
court saying that protect my personal liberties, personal laws, then the court must have been right. But he is not asking for that liberty. And we have, as a community, have felt that the Muslim person is going to the court not asking to protect the personal laws, but the Special Marriages Act. So we are at failure. We should introspect why the Muslims are going and marrying the other caste people. I am for it. I am completely for intercaste because that upholds our
I wanted to end this, but I see Ahmed Ayaz wants to respond. So does Karuna Nundy.
can I
So
make a small
Ahmed Ayaz,
response?
a minute to you, please. Yes, please go ahead, sir.
No, here the question, my friend, is here the question is not Muslim or a non-Muslim. Question is a matter of interfaith and the recognition of interfaith marriages by the constitution. So it's not that what Muslims have done and what non-Muslims have done. Question is about that
Sir,
how
but it is for that very purpose that there were religious. No,
personal laws. These
Ahmed
personal
Ayaz, sir,
laws,
wasn't it the
any
very
marriage-
fact that
any
you
marriage
had
not
the
done as per
Christian,
as per
Hindu,
personal law
and
is
the
considered to be,
Muslim personal laws, marriage
illegitimate.
acts, which
That's
did
what
not
the court has
allow
done.
for certain grounds, particularly if either of them did not want to convert? Therefore, you had a constitutional law, the Special Marriages Act. So what is the problem? I mean, I do not understand your ground. Honestly, despite you being a lawyer, and I'm not a lawyer, I'm not a legal mind, I still do not get it. Karuna Nundy, I just come to you. I'll allow Ahmed Ayaz to respond.
Because I've sent him the provision of the Constitution he's citing.
Ahmed
So
Ayaz,
maybe
please.
he can read that. I've sent the entire panel the provision of Article 25 to A, which says that nothing in this article shall affect the operation of any existing law, the Special Marriage Act, or prevent the state from making any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. So, sir, the thing is that we can't just make arguments as lawyers completely divorced of the law and the Constitution, right? Feelings have their place, but then feelings should be recognized as feelings and not as the law, and definitely not as the Constitution, which is our holy book.
Okay. Ahmed Ayaz, do you want to respond? Because that was particularly to you. But of course, this is not a personal debate. We have ensured that the discourse is never personal. We're going on arguments.
not a
We are
personal
going on
objection.
what we're trying to understand the legality of it all. Ahmed Ayaz, do you want to respond to the legal points that Karuna Nundy has made, as well as Atikur Rahman as well? Do you want to respond?
Without getting into the discussion further on this, but I hold the view that since the Article 25th, recognizes the personal laws, and as such, any marriage beyond that, the court has declared to be illegitimate, and that way, I think to that extent, the court has done the right thing, because they have held the the personal laws as recognizable under Article 25.
Amber Zaidi, you're shaking your head.
I think
30
to that
seconds
extent
before
it's
I end the show.
Sneha, we see such, contradiction in judgments because we have personal laws based on religion, and such contradiction, and the challenge before the court comes because we have such, laws based on religion. So they think what prevails, personal law prevails or Constitution of India prevails. Hence, we demand implementation of uniform civil code in the country. We have a criminal code unified for everybody, irrespective of religion, caste, and creed. Why civil laws can't be unified in the country? So the lawyers like Ahmed Ayaz would later won't be able to.
We're going on a totally different debate altogether. But totally take your point as well, Amber Zaidi. Karuna Nundy, Amber Zaidi, Ahmed Ayaz, Atikur Rahman, thank you very much for joining us, for bringing in some very important arguments and insights into a judgment that we tried hard to understand. Thank you very much.